In episode 26 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in United States Postal Service versus Konan. The case was decided February 24th, 2026. And as always, we will start with the syllabus. Respondent Labine Konan and the local post office in Ulysses, Texas, had an extended dispute concerning mail delivery to two rental properties owned by Konan. Konan alleged that, among other things, United States Postal Service employees intentionally withheld her mail and interfered with its delivery. After administrative complaints proved unsuccessful, Konan sued the United States in federal court, bringing various state law tort claims alleging that the United States Postal Service intentionally and wrongfully withheld her mail. The district court dismissed Konan's complaint pursuant to the Federal Tort Claims Act's postal exception, under which the United States retains sovereign immunity for all claims arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. 28 U.S.C. Section 2680b. The district court concluded that the United States enjoys sovereign immunity from Konan's claims because they all relate to personal or financial harms arising from non-delivery of mail. The district court further held that the postal exception is not limited to merely negligent failure to properly carry the mail. The Fifth Circuit reversed, holding that the terms loss, miscarriage, and negligent transmission do not encompass the intentional act of not delivering the mail at all. In contrast, the First and Second Circuits have interpreted the postal exception to apply to suits even when they arise from harms caused by intentional misconduct. The court granted certiorari to resolve the split. Held. The United States retains sovereign immunity for claims arising out of the intentional non-delivery of mail because both miscarriage and loss of mail under the FTCA's postal exception can occur as a result of the Postal Service's intentional failure to deliver the mail. Part A. The postal exception reflects Congress's judgment that redress for harms of the sort primarily identified with the Postal Service's function of transporting mail throughout the United States should not come from potentially burdensome tort suits. Part B. Both miscarriage and loss of mail under the postal exception can occur as a result of the Postal Service's intentional failure to deliver the mail. Section 1. The court interprets statutory terms according to the ordinary meanings they had when they were enacted. When Congress enacted the FTCA in 1946, the miscarriage of mail ordinarily included any failure of mail to properly arrive at its intended destination. Dictionaries published around that time confirm that a miscarriage of mail happened when mail failed to arrive at its destination. The court declines to limit miscarriage to negligent failures, as no dictionaries cited impose this limitation, and ordinary speakers used miscarriage to refer to problems with mail caused by intentional misconduct, such as when mail was stolen or burned. The court also declines to limit miscarriage to when mail goes to the wrong address, as speakers use the term when mail failed to reach its intended destination regardless of where the mail ended up, including when mail was delayed, came too late, or was left in the post office. Section 2. When Congress enacted the FTCA, the loss of mail ordinarily meant a deprivation of mail regardless of how the deprivation was brought about. Contemporary dictionaries defined loss as the act or fact of losing or suffering deprivation, and one can suffer a deprivation of something when another intentionally keeps that thing for himself. Konan alleged that she was entitled to possession of her mail, but that the Postal Service converted it, meaning she was deprived of the use and possession of the property. So her claims arise out of the loss of her mail. The court disagrees with the attempt by Konan to limit loss to only inadvertent losses. A loss can be the result of another person's intentional misconduct, and ordinary speakers commonly describe a loss of mail from theft, including theft by the carrier. The court also disagrees with the argument that the postal exception only applies when the Postal Service lost the mail, because Congress applied the postal exception to all claims arising out of the loss, miscarriage, or negligent transmission of mail, describing kinds of harms, not kinds of actions by the postal workers. This interpretation is consistent with the principal provision of the FTCA, which includes losses caused by intentional misconduct and does not require that the government lost anything. The court rejects Konan's proposal to limit loss only to destruction. Ordinary speakers referred to losses of mail even when the mail was not destroyed, and the dictionary definitions Konan pointed to were listed first because they were oldest, not because they were primary. Part C. The court rejects Konan's remaining argument that her claims must not be barred by the postal exception. Section 1. Konan argues that the postal exception's negligent transmission category narrows the meaning of miscarriage and loss, but Congress intentionally limited the negligent qualifier to transmission and did not use it to qualify loss or miscarriage. An adjective before the final noun in a list cannot be transplanted to qualify the preceding nouns. The court does not think that the negligent qualifier suggests that Congress was trying to enable suits involving intentional misconduct. Instead, the inclusion of negligent to qualify transmission forecloses claims involving mail even though nothing went wrong with its transport or delivery, keeping the focus of the postal exception on mail delivery problems. Section 2. Konan also argues that the court's interpretations of miscarriage and loss run afoul of the presumption against surplusage, because many claims, including Konan's here, will arise from both a miscarriage and a loss of mail. But Konan's proposal to solve the surplusage, 3 non-overlapping definitions of the statutory terms, is inconsistent with ordinary meaning, which shows that these terms are often used in an overlapping manner. In Dolan, the court interpreted the terms in the postal exception to substantially overlap, and the canon against surplusage is subordinate to the cardinal canon that a legislature says in a statute what it means and means in a statute what it says there. Congress likely used broad overlapping terms to better keep complaints about mail delivery out of court. Part D. The court does not decide whether all of Konan's claims are barred by the postal exception or which arguments Konan adequately preserved. Justice Thomas delivered the opinion of the court in which Chief Justice Roberts and Justices Alito, Kavanaugh, and Barrett joined. The United States enjoys sovereign immunity and cannot be sued without its consent. By means of the Federal Tort Claims Act, Congress waived that sovereign immunity for certain tort suits based on the conduct of government employees. But in the provision at issue in this case, Congress retained sovereign immunity for a wide range of claims about mail. Specifically, the FTCA's postal exception retains sovereign immunity for all claims arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. This case concerns whether this exception applies when postal workers intentionally fail to deliver the mail. We hold that it does. Part 1, Section A. The United States Postal Service is a frequent point of contact between citizens and the federal government. In 2024, the Postal Service's more than 600,000 employees delivered more than 112 billion pieces of mail, over 300 million a day, to more than 165 million delivery points. Unsurprisingly, given this volume, not all mail arrives properly and on time. The Postal Service reports receiving approximately 335,000 customer complaints per year. Because it is a government agency, recourse against the Postal Service in the form of lawsuits for money damages is limited. As part of the executive branch of the government of the United States, the Postal Service enjoys federal sovereign immunity absent a waiver. Before 1946, that sovereign immunity generally prevented those injured by government employees from receiving compensation through lawsuits. That year, Congress enacted a limited waiver of immunity through the FTCA. Subject to enumerated exceptions, the FTCA allows a plaintiff to sue the government for injuries or loss of property caused by the negligent or wrongful act or omission of a federal employee acting within the scope of his office or employment. The FTCA's postal exception retains the government's sovereign immunity for lawsuits about failing to properly carry or deliver mail. It forecloses any claim arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. This court has interpreted the postal exception to apply when the plaintiff is harmed because mail either fails to arrive at all or arrives late, in damaged condition, or at the wrong address. Section B. This case arises from the dismissal of a complaint, so we accept the complaint's allegations as true, although the government disputes them. Respondent Labine Konan owns 2 houses a block apart in Ulysses, Texas, one on Saratoga Drive and the other on Trenton Lane. Konan leases rooms to tenants in both houses and occasionally stays at them herself. The Postal Service delivers mail for all the houses in the neighborhood to a central structure with a box for each house. The Postal Service distributes keys to the owners of the houses so that they can retrieve their mail. As the homeowner, Konan received the keys to the boxes for both houses. Konan kept the keys and distributed the mail to her tenants daily, and she also received some of her own mail at the Saratoga address. Konan's grievances with her mail service began in May 2020. After Konan noticed that no mail had arrived at her Saratoga house in several days, she learned that the assigned carrier had changed the listed owner from Konan's name to a tenant's name. The same carrier then authorized a change of the lock to allow the tenant to have his own mail key without Konan's consent. Konan confronted the employees at the local post office about these changes. A supervisor at the local post office explained to Konan that the Postal Service would stop delivering mail to her Saratoga address until the Postal Service Inspector General's office investigated and determined the proper owner. Konan then received no mail to the Saratoga address for a couple of months before service resumed. Konan then learned that the same carrier had mail addressed to her and her tenants returned to senders as undeliverable. As a result, Konan and her tenants did not receive important mail. Konan resorted to private carriers. The disruptions in mail service resulted in the loss of tenants and made it more difficult for Konan to attract new tenants. The carrier also taped a red notice inside the mailbox stating that mail addressed to some but not all of the Saratoga residents could be delivered to the box. In 2021, postal workers also allegedly stopped delivering mail to the Trenton house after discovering that Konan owned it as well. In response, Konan signed up for the Postal Service's Informed Delivery Service, which allows customers to view scans of incoming mail. When she discovered that mail on its way to her addresses was not being delivered, she requested that the mail for the Saratoga residents be held at the post office so that she could retrieve it in person. But the postal employees did not give her the mail because Konan failed to provide identification for the addresses. In addition to these efforts, Konan also filed administrative complaints, but without success. Section C. In January 2022, Konan sued the United States in federal court. Konan alleged that the Postal Service intentionally and wrongfully withheld her mail. As relevant here, Konan brought claims under state law for nuisance, tortious interference with prospective business relations, conversion, and intentional infliction of emotional distress. She sought damages for loss of rental income, the deprivation of her rightful mail, and the distress that the postal workers had caused her. Footnote 1. Konan also brought discrimination claims against the postal workers under 42 U.S.C. sections 1981 and 1985, alleging that they were motivated by racial animus. The district court dismissed these claims. The Court of Appeals affirmed. We denied Konan's cross-petition for certiorari regarding those claims, so they are not before us. Carrying on. The district court dismissed Konan's complaint based on sovereign immunity. Relying on the postal exception, it concluded that the United States enjoys sovereign immunity from her claims because they all relate to personal or financial harms arising from non-delivery of sensitive materials or information and other mail. The district court held that the postal exception is not limited to merely negligent failure to properly carry the mail. The Court of Appeals for the Fifth Circuit reversed. It held that the terms loss, miscarriage, and negligent transmission do not encompass the intentional act of not delivering the mail at all. It reasoned that Konan's claims did not arise out of the loss of mail because the mail was not destroyed or misplaced by unintentional action. It also reasoned that Konan's claims did not arise from the miscarriage of mail because there was no attempt at a carriage. And it reasoned that Konan's claims did not arise from the negligent transmission of mail because the postal workers' actions were intentional. The Fifth Circuit's decision conflicts with those of the First and Second Circuits, which have interpreted the postal exception to apply to suits even when they arise from harms caused by intentional conduct. We granted certiorari to resolve the split. Part 2. The postal exception retains the federal government's sovereign immunity for any claim arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. The postal exception reflects Congress's judgment that redress for harms of the sort primarily identified with the Postal Service's function of transporting mail throughout the United States should not come from tort suits. Given the frequency of postal workers' interaction with citizens, those suits would arise so often that they would create a significant burden for the government and the courts, and their cost to taxpayers would depend on the value and importance of the mail's contents, over which the government typically has no control. According to Konan and the dissent, the postal exception does not apply to Conan's claims because she alleges that the postal workers intentionally refused to deliver her mail. We disagree. Both miscarriage and loss of mail under the postal exception can occur as a result of the Postal Service's intentional failure to deliver the mail. Section A. Absent a reason to think otherwise, we interpret statutory terms according to the ordinary meanings they had when they were enacted. When Congress enacted the FTCA in 1946, the miscarriage of mail ordinarily included any failure of mail to properly arrive at its intended destination. Konan would limit miscarriage to unintentional failures or failures where the mail went to the wrong address. Neither limitation is well founded. Dictionaries published around the time Congress enacted the FTCA confirm that a miscarriage of mail happened when mail failed to arrive properly. 2 dictionaries indicate that miscarriage of mail meant the failure of a letter to reach its destination. In a third, miscarriage meant the failure of something sent to arrive. Something can fail to happen as a result of intentional misconduct. Because a miscarriage includes any failure of mail to arrive properly, a person experiences a miscarriage of mail when his mail is delivered to his neighbor, held at the post office, or returned to the sender, regardless of why it happened. Conan's claims about the Postal Service's willful failure to deliver her mail therefore result from the miscarriage of her mail. We disagree with Conan's attempt to limit miscarriage to negligent failures of mail to arrive properly. Neither Konan nor the dissent cites any dictionaries imposing this limitation. Instead, Konan cites examples of uses of the term miscarriage that suggest that the miscarriage in question was unintentional, such as an 1868 telegraph law decision explaining that a telegraph company should not be liable for every mistake, miscarriage, or accidental delay that may occur. We agree that miscarriage of the mail can be unintentional, but the fact that the phrase was commonly used in a particular context does not show that it is limited to that context. In fact, ordinary speakers used miscarriage to refer to problems with mail caused by intentional misconduct. When a mail pouch was stolen, a newspaper reported that the letters miscarried. When a priest failed to receive a summons because it was burned by an ecclesiastic, the headline read, "His letter miscarried." And when litigants' documents failed to arrive, courts classified miscarriage of mail as an excuse, without any suggestion as to whether the carrier acted intentionally. We see no reason to suppose that these uses of miscarriage were extraordinary. Konan separately contends that a miscarriage of mail happens only when the mail goes to the wrong address, not when it is, like her mail, held at the post office or returned to the sender. We again decline to impose a limitation that has no basis in the dictionaries or ordinary usage. Speakers use the term miscarriage when the mail failed to reach its intended destination regardless of where it ended up. One newspaper, for example, explained that a letter miscarried because it was delayed. Another ran a story in which a correspondent's letter miscarried and came too late. And a court described mail mistakenly left in the post office as having miscarried. We decline Konan's invitations to artificially narrow ordinary meaning. A miscarriage of mail includes failure of the mail to arrive at its intended destination regardless of the carrier's intent or where the mail goes instead. Section B. Konan's withholding claims also arise out of the loss of mail and are therefore within the postal exception. When Congress enacted the FTCA, the loss of mail ordinarily meant a deprivation of mail regardless how the deprivation was brought about. So, like miscarriage, intentional refusal to deliver mail could cause the loss of mail. A loss of mail is a deprivation of mail. loss is a generic and relative term. It is not a word of limited, hard, and fast meaning, but it is commonly used to refer to any deprivation or that which is withheld, such as when someone suffers the loss of property in a fire or the loss of income from being laid off. Webster's defined loss as the act or fact of losing in various senses or suffering deprivation. Oxford English Dictionary defined it as being deprived of or the failure to keep something. One can, of course, suffer a deprivation of something when another intentionally keeps that thing for himself. Konan alleged that she was entitled to the possession of her mail, but that the Postal Service converted it. Conversion means that Konan was deprived of the use and possession of the property in question. Konan's claims therefore arise out of the loss of her mail. As with miscarriage, we disagree with Konan's attempt to limit loss to only inadvertent losses. A loss can be the result of another person's intentional misconduct. One can, for example, suffer a tax loss that results from embezzlement. An army can suffer loss of soldiers as a result of the intentional conduct of the enemy. And in the mail context, ordinary speakers commonly described a loss of mail from theft, including theft by the carrier. Just a year before Congress enacted the FTCA, the Army explained that virtually all loss of mail through theft occurs at terminal transfer points outside this country. A few years earlier, a reported loss of local mail was caused by a rogue mail handler who admitted the theft of considerable mail during the past few months. Pre-FTCA decisions also described a loss of mail when the carrier stole it. We also disagree with Konan's and the dissent's rejoinder that the postal exception applies only when the Postal Service lost the mail. Congress could have written the postal exception to apply when the Postal Service lost, miscarried, or negligently transmitted mail, but Congress applied the postal exception to all claims arising out of the loss, miscarriage, or negligent transmission of mail. It describes kinds of harms, not kinds of actions by the postal workers. We decline to rescue Konan's claims by inserting the Postal Service as the sentence's subject and then converting the three nouns into three verbs. Our interpretation of loss is also consistent with the principal provision of the FTCA. Under that provision, a plaintiff must allege a loss of property caused by the negligent or wrongful act or omission of a federal employee. All agree that this provision includes losses caused by intentional misconduct and does not require the government lost anything. Because Congress used loss in this sense in the FTCA's principal provision, our interpretation adheres to the unrebutted presumption that the term bears a consistent meaning throughout the FTCA. Last, Konan proposes limiting loss to only destruction. She contends that the primary meaning of loss in 1946 was destruction, not any other kind of deprivation. But, as we have explained, ordinary speakers referred to losses of mail even when the mail was not destroyed. Judge Cardozo wrote that when an envelope fell behind a radiator in the post office, it caused the loss of the checks inside even though they were later recovered. And contemporaneous regulations treated loss and destruction separately, not, as Konan suggests, synonymously. Konan asserts that destruction was the primary meaning of loss because it was listed as the first definition in dictionaries. But although many people assume that the first sense listed in a dictionary is the main sense, that is often quite untrue. The definitions Konan pointed to were listed first because they were the oldest, not because they were primary. We do not presume that Congress intended the oldest usage, but rather the ordinary one in 1946, and contemporaneous evidence shows that Konan's usage was not the primary one. Part 3. Konan proffers two remaining arguments that her claims must not be barred by the postal exception. We address them in turn. First, Konan argues that the postal exception's negligent transmission category narrows the meaning of miscarriage and loss. She argues that the qualifier negligent in the term negligent transmission implicitly qualifies the other two terms, but Congress intentionally limited the negligent qualifier to transmission and did not use it to qualify loss or miscarriage. Konan's argument seems to assume that pairing a broad statutory term with a narrow one shrinks the broad one, but there is no such general usage. Just like a limiting clause or phrase should ordinarily be read as modifying only the noun or phrase that it immediately follows, an adjective before the final noun in a list cannot be transplanted to qualify the preceding nouns. We also do not think that the negligent qualifier suggests that Congress was trying to enable suits involving intentional misconduct. If Congress had written the postal exception to refer to all transmission of mail, the category, unlike miscarriage and loss, would have encompassed claims that involved mail even though nothing went wrong with its transport or delivery. The inclusion of negligent to qualify transmission forecloses that result and thereby keeps the focus of the postal exception on mail delivery problems, but in doing so, it does not limit the other two categories. Second, Konan argues that our interpretations of miscarriage and loss run afoul of the presumption against surplusage. On our interpretation, she argues, many claims, including Konan's here, will arise from both a miscarriage and a loss of mail, making one or the other redundant. To resolve surplusage, Konan proposes three non-overlapping definitions. Loss covers damage to mail, miscarriage covers what happens to mail when it leaves USPS's custody and ends up in the wrong place, and negligent transmission covers detention or delays of the mail while still in the USPS's possession. Konan's proposal is inconsistent with ordinary meaning, which shows that these terms were often used in an overlapping manner. And in Dolan, the court interpreted the terms in the postal exception to substantially overlap. The canon against surplusage is subordinate to the cardinal canon that a legislature says in a statute what it means and means in a statute what it says there. We think that Congress likely used broad overlapping terms to better keep complaints about mail delivery out of court. Part 4. We hold that the postal exception covers suits against the United States for the intentional non-delivery of mail. We do not decide whether all of Konan's claims are barred by the postal exception or which arguments Konan adequately preserved. We vacate the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. It is so ordered. Justice Sotomayor, with whom Justice Kagan, Justice Gorsuch, and Justice Jackson join, dissenting. For 2 years, respondent Libene Konan and her tenants did not receive mail addressed to the rental properties that Konan owned. According to Konan, negligence was not to blame. Quite the opposite. She alleges that the United States Postal Service employees intentionally withheld delivery because they did not like that a black person owned the properties and leased rooms to white people. Konan brought this action under the Federal Tort Claims Act, FTCA, against the United States to recover damages she sustained as a result of this alleged years-long harassment campaign. The United States is generally protected by sovereign immunity, but Congress, through the FTCA, has enacted a capacious waiver of that immunity for tort suits when an individual is harmed by a federal employee acting within the scope of her employment. That waiver, however, is subject to several exceptions. Today, the court holds that one exception, the postal exception, prevents individuals from recovering for injuries based on a postal employee's intentional misconduct, including when an employee maliciously withholds her mail. Because this reading of the postal exception transforms, rather than honors, the exception Congress enacted, I respectfully dissent. Part 1. The FTCA serves a simple purpose: to remove the sovereign immunity of the United States from suits in tort. This broad waiver of immunity allows an individual harmed by a federal employee acting within the scope of its office or employment to recover for injuries or loss of property or personal injury or death caused by the employee's negligent or wrongful act or omission. Congress has also enacted several exceptions preserving the United States' immunity in some circumstances. The exceptions are designed to protect certain important governmental functions and prerogatives from disruption. They thus mark the boundary between Congress's willingness to impose tort liability upon the United States and its desire to protect certain governmental activities from exposure to suit by private individuals. At the same time, courts must be careful not to interpret these exceptions too broadly. Unduly generous interpretations, this court has warned, run the risk of defeating the central purpose of the statute, to waive the government's immunity from suit in sweeping language. To harmonize these considerations, the proper objective of a court attempting to construe one of the exceptions is to identify those circumstances which are within the words and reason of the exception, no less and no more. This case calls on the court to interpret the postal exception, which covers any claim arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. The wording of this exception is noticeably narrower than some of its neighbors. For example, all claims for damages caused by the fiscal operations of the Treasury or by the regulation of the monetary system are barred. So too are all claims arising from the activities of the Tennessee Valley Authority, the Panama Canal Company, and a federal bank, a federal intermediate credit bank, or a bank for cooperatives. By comparison, Congress did not paint with as broad of a brush in designing the postal exception. Like it had for these other agencies and activities, Congress could have granted immunity for all claims arising from the mail activities of the Postal Service. Instead, Congress identified certain misconduct for which the government was not assuming financial responsibility, namely the loss, miscarriage, or negligent transmission of letters or postal matter. By using specificity over generality, it follows that Congress intended for this exception to be less encompassing than the coverage provided by the broader exceptions, and for the government to assume financial responsibility for certain classes of misconduct related to postal activities. This court has already identified some of those classes. In Kosak, the court explained that claims arising from car accidents caused by postal employees delivering mail fall outside the exception. In Dolan, the court recognized a second class of claims for slips and falls caused by an employee negligently placing a package on a porch step. Today, I would have affirmed the Fifth Circuit's well-reasoned decision that acknowledged a third class, claims concerning intentional misconduct committed by postal employees, which would necessarily include withholding a person's mail for malicious reasons. Part 2, Section A. The postal exception's text shows that Congress did not intend to immunize intentional misconduct. Recall that the exception covers the loss, miscarriage, and negligent transmission of mail. As Kosak observed, the terms describe three categories of misconduct that postal employees can commit without incurring liability for the United States. The majority, however, contends that these terms focus on harms rather than government wrongdoing, citing Dolan. To be sure, Dolan described these terms as harms, but in the same breath, it also emphasized that the three terms protect only a subset of postal wrongdoing. A focus on misconduct is consistent with most other FTCA exceptions, which generally are triggered by certain types of government conduct rather than the type of harm the plaintiff experiences. For instance, some exceptions directly cover different acts or omissions of government employees. Another addresses intentional actions by employees, capturing, for example, assault, battery, false imprisonment, and other intentional torts like them. A different group immunizes the activities of a given government instrumentality. Yet a different subset describes a specific type of government action, such as the assessment or collection of any tax or customs duty, the imposition or establishment of a quarantine, and the fiscal operations of the Treasury. The focus of each is on the government conduct. The same is necessarily true of the postal exception. The key question is thus as follows: what kind of misconduct falls within the words and reason of the postal exception? All signs point to Congress leaving intentional misconduct outside the exception's scope. Subsection 1. Begin with negligent transmission. This term covers negligence causing mail to be lost or to arrive late, in damaged condition, or at the wrong address. It goes without saying that this term therefore does not immunize intentional misconduct. Beyond that insight, however, Congress's express inclusion of negligent transmission provides other important clues for deciphering statutory meaning about the scope of the postal exception. As the majority recognizes, if Congress had included all claims arising out of the transmission of mail in the postal exception, the term would have encompassed claims that involved mail even though nothing went wrong with its transport or delivery. To avoid that outcome, Congress needed to add a narrowing modifier to focus on when things go wrong. Footnote 1. Congress did not need to add negligent before miscarriage or loss because the ordinary meaning of those terms plus statutory context convey inadvertence on their own. Carrying on. Critically, Congress did not have to choose negligent as that modifier or the only modifier. Congress could have, for example, modified transmission with both negligent and wrongful. Doing so would have avoided the problem the majority identifies while also clarifying that both classes of conduct fall within the exception's scope. Yet Congress elected to immunize negligent conduct alone. Its choice to do so carries significance. It raises the natural inference that Congress intended for at least some intentional wrongdoing related to transmitting mail to fall outside the scope of the exception. Indeed, before this court, the government emphasizes repeatedly that negligent transmission is significant because the term shows that Congress knew how to exclude intentional conduct when it wanted to. Yet according to the government and the majority, this was a hollow choice. In their view, Congress excluded some set of intentional conduct through the negligent transmission modifier only to sweep that conduct back into the exception through miscarriage and loss. The majority adopts the government's definition of miscarriage as capturing situations where mail fails to arrive properly, regardless of the actor's intent. It also adopts the government's definition of loss as capturing the deprivation of mail, regardless, again, of the depriver's intent. It is difficult to see how a postal employee could intentionally transmit mail wrongfully, such as by refusing to deliver the mail, lighting it on fire, or shredding it into pieces, without falling within these definitions of miscarriage or loss. In this world, Congress did not even need to bother with the modifier to transmission that it adopted. Congress did not make this odd choice. As explained below, loss and miscarriage as used in the postal exception do not capture intentional misconduct either. Subsection 2. Turn then to loss. As the government acknowledged in its petition for certiorari, loss is ordinarily understood to capture unintentional conduct. For good reason. As the Fifth Circuit observed below, no one intentionally loses something. People lose their keys when they misplace them, not when they give them to their children. People lose their mail when it gets stuck behind a drawer, not when they intentionally throw it away. If someone said they lost their car, no one would think it was stolen, only that the person forgot where they had parked it. The same is true when the Postal Service loses someone's mail. The reason is an error, not deliberate wrongdoing. To reach its contrary result, the majority defines loss as any deprivation of mail, which it concludes captures all situations where the individual does not receive mail, no matter the cause. To do so, however, the majority must shift away from a focus on harms that befall the mail to harms that befall Konan. The majority says that the postal exception encompasses 3 kinds of harms, not kinds of actions by the postal workers. The majority defines the first 2 terms, miscarriage and negligent transmission, to encompass harms to the mail, yet under the majority's interpretation, loss is an entirely distinct kind of harm. That is because the mail does not suffer a deprivation in the same way that mail fails to arrive, miscarriage, or mail is damaged due to negligent transmission. The only way loss could mean a deprivation is if it were a harm experienced by Konan, not by the mail. No such inconsistency, however, arises if, as explained above, all 3 terms are read to refer to the government's misconduct, the Postal Service's loss, miscarriage, or negligent transmission of mail. When used in this sense, loss plainly and sensibly denotes unintentional conduct consistent with its ordinary meaning. Footnote 2. The government also contends that loss in the postal exception incorporates intentional misconduct because it asks whether the alleged victim lost the mail. That again requires the same shift in perspective, asking on one hand whether mail was miscarried or negligently transmitted by the Postal Service, and on the other hand whether Konan lost and so was deprived of her mail. Carrying on. The majority also invokes the presumption of consistent usage. It points to the use of loss in the FTCA's sovereign immunity waiver as meaning deprivation and argues that loss as used in the postal exception must take on the same meaning. The consistent usage canon, however, readily yields to context. And here, comparing the context of the FTCA's waiver to the context of the postal exception shows that loss is being used in 2 different ways. The waiver uses loss to describe the form of damages an individual harmed by a federal employee can seek to recover. It states that plaintiffs can bring claims against the United States for loss of property caused by the negligent or wrongful act or omission of any employee of the government while acting within the scope of their employment. The plaintiff's loss could be due to negligent or wrongful conduct, as the waiver states explicitly. In contrast, the postal exception uses loss to describe the form of the employee's misconduct that is protected from liability. If an employee lost the mail, the plaintiff suffered a loss under the waiver, and the claim arose out of the loss of the mail, meaning the postal exception applies. If an employee intentionally destroyed the mail, the waiver would still be implicated because the plaintiff suffered a relevant loss for purposes of the waiver. The postal exception would not apply, however, because the employee destroyed the mail and did not lose it. Loss is thus being used clearly in two different ways and carries two different meanings. Subsection 3. That brings us to miscarriage. The majority is correct that miscarriage covers misconduct by the Postal Service that causes mail to fail to arrive properly. But the majority is wrong to extend this meaning to cover situations that involve intentional misconduct. As the majority recognizes, miscarriage commonly covers negligence or inadvertence. Indeed, there are many examples of miscarriage being used when mail fails to arrive due to negligence, including as illustrated by the government's own cases. From here, as the majority sees it, mail that is intentionally not delivered, even for malicious reasons, also failed to arrive properly, so Congress must have intended to include intentional misconduct within the exception by using miscarriage. The majority, however, offers no persuasive evidence suggesting that miscarriage is commonly used in this way. To start, the majority relies on several dictionary definitions. None of those definitions address an individual's mens rea. The phrase failure to arrive, moreover, does not immediately suggest intentional wrongdoing. A diplomat might fail to arrive at a treaty negotiation if her flight were canceled, but no one would describe her as failing to arrive if she deliberately skipped the talks to undermine the treaty. Refused to attend would be more accurate. Next, the majority turns to real-life examples. Here, the majority does not rely on any cases cited by the government. That is not a surprise, as the government failed to identify a single example of miscarriage being used to describe mail failing to arrive properly due to intentional misconduct. Footnote 3. This is a number of citations to cases using the term miscarriage or similar to refer to unintentional conduct. I'm not going to read them all out. Carrying on. The majority thus searches elsewhere, citing examples of its own, two cherry-picked newspaper references almost 20 years apart and at least 30 years before the enactment of the FTCA that used miscarried, not miscarriage. If miscarriage were in fact ordinarily used to describe intentional misconduct, one might expect that actual examples of the usage would be easier to come by. The majority also cites cases in which the reason behind a miscarriage was not identified, but those cases do not support its position. How a word is used when the cause is unknown hardly informs whether an ordinary speaker would use the same word when the cause is known. Those cases, moreover, simply reflect the general presumption that issues with mail are typically not a result of intentional misconduct by postal workers. For example, in Lake v. Lake, the court explained that when a motion arrived in court a day late due to a miscarriage of the mails, with no further cause explained, that mere accident should not be held against the party. Similarly, in Wagner v. Lucas, the court described a miscarriage of the mails as a situation that human prudence, foresight, and sagacity could not prevent, like a mistake in the wording of a telegram. Accordingly, the use of the term miscarriage in these cases does not prove that the term covers intentional misconduct. In context, had the courts suspected that the late delivery, for instance, was a result of such misconduct, they likely would have used a different word. The contemporaneous postal laws and regulations from before the FTCA was enacted, the backdrop against which Congress enacted the postal exception, further undermine the majority's interpretation. For example, those regulations directed the Division of Stamps to make adjustments in cases of loss, miscarriage, or detention of stamped supplies in transit. This suggests that when the stamped supplies were intentionally held back and not delivered, i.e. failed to arrive, detention was used instead of miscarriage, even though, on the majority's reading, miscarriage would have sufficed. The regulations also directed postal employees to hold packages dropped off for forwarding if they contained destructive mail matter, to notify the sender of the detention of the package and to let them know it cannot be transported by mail. This is another use of detention in the context where, under the majority's view, miscarriage would have been appropriate because the mail failed to arrive at its destination. Yet in each, the cause of the non-delivery was known, it was not inadvertence, and a different term was used. At most, the majority shows that certain dictionary definitions of miscarriage could conceivably capture intentionally withholding mail, or tearing up a letter into pieces, or lighting a package on fire. In all those situations, the mail failed to arrive properly. That a definition is broad enough to encompass one sense of a word, however, does not establish that the word is ordinarily understood in that sense. Here, neither the majority nor the government has offered any meaningful evidence supporting the view that miscarriage was commonly used in situations when the mail failed to arrive properly due to intentional wrongdoing, and that, by including miscarriage within the postal exception, Congress intended to capture such wrongdoing. If there were any doubt, the words surrounding miscarriage resolve it. As the court in Dolan explained, when construed in context, a word in a statute may or may not extend to the outer limits of its definitional possibilities. For example, a word is known by the company it keeps, and words grouped in a list should be given related meaning. Without this rule, courts risk ascribing to one word a meaning so broad that it is inconsistent with its accompanying words, thus giving unintended breadth to the acts of Congress. Here, reading miscarriage to capture intentional misconduct does precisely that. As noted above, the word loss typically connotes negligence, and the majority's reading makes Congress's specific inclusion of the negligent modifier for transmission entirely ineffective at serving its purpose, excluding intentional misconduct. There also does not appear to be any good reason why Congress would have wanted one term, miscarriage alone, to cover intentional misconduct and not the other two terms. Indeed, under the majority's broad definition of miscarriage, the words loss and negligent transmission become no more than misleading surplusage. Section B. For all these reasons, a faithful interpretation of the postal exception leads to the conclusion that intentional misconduct is excluded from its reach. Congress used overlapping terms in the exception, but Congress intended for that overlap to keep claims alleging negligence, not intentional wrongdoing, out of court. This reading gives meaning to Congress's choice to put negligent before transmission and to use the words miscarriage and loss in their common understanding, and it respects the specificity Congress used in the postal exception as compared to the broadly worded exceptions Congress used for other agencies. Undeterred by this evidence, the majority gives the Postal Service the blanket exception Congress withheld. In its view, the exception immunizes the agency for all intentional and non-intentional actions in the delivery of mail, apart from auto accidents and slips and falls, as Dolan and Kosak require. Relying on loss, miscarriage, and negligent transmission is an odd way to cover this waterfront. If Congress had intended this outcome, why not follow the same approach that it used for other broad exceptions in the FTCA? The answer is that Congress intended no such thing. By expanding the words and reason of the postal exception beyond their specific scope, the majority undermines the sweeping waiver of immunity Congress adopted. Contrary to the majority's suggestion otherwise, adhering to the text Congress enacted would not flood the government or courts with frivolous lawsuits. Footnote 4. The majority points to the 335,000 complaints filed with the Postal Service each year to suggest that those claims arise out of mail failing to arrive properly and on time. This is misleading. As Konan explains, those complaints include everything from rude or unprofessional employee behavior to complaints about vehicle parking. Submitting a customer complaint, moreover, requires typing a few sentences into an online form, whereas filing an FTCA claim requires first exhausting administrative remedies and then filing suit in court. The raw number of complaints, therefore, does not provide an accurate gauge of the consequences for recognizing that intentional misconduct does not fall within the postal exception. Carrying on. That is because the FTCA has additional safeguards that bar many claims premised on intentional misconduct. Liability for the United States will arise only in the rare situation where the employee's intentional conduct is tortious, falls within the scope of her employment, and falls outside of the due care and discretionary function exceptions. For example, the majority cites one case of an insurance company suing after a federal employee stole an expensive package it had insured, but most states likely do not consider intentional torts like theft to fall within an individual's scope of employment. The United States, accordingly, would not incur liability in those circumstances or others involving claims of similar misconduct. In addition, there are ordinary litigation tools to prevent any threat of abuses, from Rule 11 of the Federal Rules of Civil Procedure to the plausibility standards in Bell Atlantic Corp v. Twombly and Ashcroft v. Iqbal. These tools suffice in many other circumstances where the threats of disruption posed by large volumes of litigation are also high. Other exceptions, like the intentional tort exception and the due care exception, turn on government officials' mens rea, and courts are well equipped to assess the plausibility of any given case based on the facts before them. Finally, even if ruling for Konan today would mean more suits against the government for mail-related intentional torts tomorrow, that would not provide this court with authority to change the text Congress enacted. Ultimately, this regime is the consequence of Congress's choice to have the exception turn on certain types of misconduct rather than providing the Postal Service with a blanket exception. It is not the role of the judiciary to supplant the choice Congress made because it would have chosen differently. Today, the majority concludes that the postal exception captures and therefore protects the intentional non-delivery of mail even when that non-delivery was driven by malicious reasons. Because this interpretation expands the scope of the exception beyond what it can reasonably support and undermines the FTCA's sweeping waiver in the process, I respectfully dissent. And that is it for the opinions in this case. I honestly don't think I have a whole lot to say about this one. I mean, this is a 5-4 decision, so I mean, it's as close as you can get. And as you might expect from that sort of narrow split, it seems to me like both sides of the argument have some pretty strong merits. I think the majority is probably strongest as applied to miscarriage. Just the plain meaning of the term, to me, it seems intuitive, I guess, that it would cover, any miscarriage of the mail, whether intentional or negligent. I think the majority has a much harder time with loss. I mean, the word loss just kind of, again, intuitively connotes a non-intentional deprivation. But yeah, I think overall the minority, the dissent, is probably correct, or at least I sympathize with them more. Like you read this provision and it kind of sounds like it's referring to non-intentional conduct. Like, sure, miscarriage could refer to intentional or non-intentional misconduct, or it's more intuitive that it could be broad enough to cover both. But then you get to loss and negligent transmission, it's like, okay, that sounds like it's dealing with non-intentional conduct. So you read the terms in context, you read them in the context of their surrounding surrounding peers, I guess, the surrounding words. Sounds like this provision is referring to actions that are non-intentional in nature and not sweeping in intentional ones. And I think the dissent has some good points, like, well, I mean, that, first of all, that, the context of the surrounding words tends to connote a sort of non-intentional nature to this whole thing, but also, like, Congress, uses the term negligent transmission, excluding at least some kinds of intentional wrongdoings, but then sweeps them back in with miscarriage and loss. And the majority has an explanation for that. They say, oh, well, the negligent transmission thing, that term isn't there to exclude intentional misconduct. It's there to ensure that suits don't arise out of or suits don't go to court arising out of the transmission of the mail, despite the fact that nothing actually went wrong with the transmission of the mail. Yeah, and then the dissent, the dissent responds, well, they didn't have to use the word negligent to do that. They specifically did use the word negligent to do that. So, there has to be a reason for that, or, we would think there would be a reason for that. I don't know. This is an area of law that, well, I mean, not that I'm particularly familiar with any area of law. Again, I'm a layman, but this is an area of law that, I don't have any particular familiarity with. I mean, I've thought about and looked into and been interested in at least one other case dealing with the FTCA, but had nothing to do with the postal exception. And yeah, again, only one other case. So I know what the FTCA is, I know what it does, I know what it's for, but I don't know practically anything about this area of law. So this is a little bit vibes based. Just okay, well, what does this sound like it's trying to get to? And I mean, that's kind of a little bit where the dissent is coming from, and probably why Gorsuch is joining the dissent. Okay, just look at the text. What does the plain meaning of the text seem to connote? To an ordinary reader, what is the ordinary meaning of this? And I don't know, it seems to me, and apparently to the dissent, like the ordinary meaning of this is it's getting at unintentional misconduct, not intentional misconduct. And so intentional misconduct falls outside the postal exception being an exception to the waiver of sovereign immunity. So intentional misconduct does not get the government's sovereign immunity. Yeah, and aside from the legal merits, I don't think the practical implications support the dissent's position. I don't think they're relevant to the dissent's position or the legal fight. I think the practical implications are completely immaterial, but there are practical reasons that I have for liking or for preferring the dissent's position, or at least the outcomes of the dissent's position. I don't like when the government, screws people over and then gets to hide behind sovereign immunity, you can't sue us. I think sovereign immunity is well based in the law. It's just I would prefer the government waive its sovereign immunity when it does stuff wrong more. And so, yeah, if the government's waiving its sovereign immunity, I tend to prefer the outcomes of decisions reading that waiver more broadly. But again, that's not a reason to read it more broadly. I think it's completely immaterial. It's just my bias is on the table, I guess. I don't like the government invoking sovereign immunity when it screws people over in order to shield itself from liability. And speaking of practical implications, Sotomayor kind of chides the majority for being concerned about practical implications of the minority's reading of the dissent's reading, saying, well, the United States Postal Service does so much work and gets so many complaints because it's doing so much that is directly interfacing with the citizenry, more so than probably any government institution. There's going to be, if we read the postal exception to not cover intentional misconduct, there's going to be this flood of litigation. That's not true. There's never a flood of litigation. That's always invoked, or that's often invoked, I should say, and it just never materializes. Courts have all sorts of tools to keep litigation out of court, and there's so many barriers to filing and sustaining a lawsuit. There's never a flood of litigation. If somebody tells you, no, we can't do this because there will be a flood of litigation, first of all, completely immaterial to the legal analysis. Second of all, No, there won't. Anyway, the majority says, oh, there will be this flood of litigation. Sotomayor says, hey, that's immaterial to the legal analysis. Like, we don't get to read the statutes Congress passes differently just because, well, we don't like the practical implications. We're not policymakers, we're judges. And that's all well and good. That's true. I think it's a little hypocritical coming from Sotomayor because she and the other liberal justices are not, not the only ones guilty of this, but she and the other liberal justices definitely make a big deal out of practical implications and whatnot when it suits them, which I dislike when they do it. I dislike when the conservative justices do it as well. But I think worth pointing out there, like, she is not innocent of this thing that she criticizes the majority for doing. But anyway, all that said, and that was a lot more than I thought I would have to say. If I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts. And if you'd like to support the show, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to bonus and exclusive content, which I have actually released a little bit of. And they can request specific content, including other than reading Supreme Court opinions. Spoiler, the bonus content I just released is content other than reading Supreme Court opinions. With that, tune in for the next episode where we will continue on through the Supreme Court's 2025 term. Until then.